thank you very much for reading my tribute already. I'm just modest. So we have a Land Act, which was passed by Parliament in 2020. And I must say that the members of Parliament and the general public who participated have indeed given us one of the best legislations on land and matters relating to land. When it comes to rights, property rights, before the Land Act, the Constitution itself has guaranteed the right to own property. Article 18 and 20 provide for these rights and the extent to which they are guaranteed. Of course, the state may, under certain circumstances, compulsorily take away from you or compulsorily acquire your land for the benefit of the general public, and you'll be entitled to compensation and all the other rules that you can apply in terms of how much compensation and resort to court and all that. So right to property has been guaranteed. In fact, Article 13(2)(c) provides that you have a right to preserve or protect your property to the extent of even causing death. I'm not giving an advice, but it says you must apply reasonable force in defending your property. So it's not that somebody just comes to say that this land belongs to me. Then you say, wait for me. You go to your room and bring a gun and kill him. You have committed an offense. That is where you apply reasonable force under circumstances. The Constitution, in taking seriously the rights of we humans to property, has indicated or provided in this Constitution with the Supreme Law of Ghana the importance to which it attaches to protection and preservation of property, both for us and even companies that may also own property. Then in the Land Act, for the first time, there has been provision on electronic transactions or conveyance, which is very, very impressive, innovative as well. Unlike previously where you have to carry out all your transactions. In fact, many years ago, that's why it's called indenture. It is believed that there were specially provided forms which had been indented, and without that, you may not be said to have owned a particular land you would have paid for already, just because the form of the paper that the agreement has been spelled on did not conform to the standard in terms of form. Now you can just engage in land transaction through electronic recordings, and that will be accepted. So I think that is quite impressive. And also, in brief, we need to know the systems of land registration and recording. So we have three systems. And we have recording of customary interests and rights by the Customary Land Secretariat, which is also a new legal framework, that an institutional framework that has been provided. Then we have registration of instruments relating to land. So your land documents have to be registered. And then registration of title, interest, and rights. Previously, we had two separate laws, one for registration of instruments, that's the document that contains the transaction, and then another one for registration of interest in land or rights or title to land. Now that act has repealed all those laws and consolidated them in the new Land Act. So we have these three systems. And then also the next question is, what are the interests that are registrable? So is it any transaction concerning land that is registrable? The law has provided under Section 81 that the interests in land which are registrable, some of them have strange names, but I'll still mention. We have the allodial title, common law freehold, customary law freehold, usufructory interest, leasehold interest, and customary tenancy. The law provides for incidents of all these interests. Then also, apart from the interest, there are rights that are also registrable. And so, especially for companies who take mortgages or engage in bank transactions for financial facilities, and you need to provide security or mortgage. A mortgage, especially by banks, have a right in the subject matter of a mortgage, and that is registrable. Then easement, in simple terms, there's always supposed to be some limited path or maybe road between your property and another person's property. And that is also a right that you can register. That you go to lands and say that I have entitlement to use this particular road. Of course, you must show that without that, your free movement, maybe to and from and to your house, will be hampered or impeded. You can register that right. That's easement. Then restrictive covenant. These are also some of the terms that are usually contained in contracts or leases attaching to land. Then another strange one, it's called profit apprendre. I think you understand French more than I do, frankly. All right, so how I understand this is, for example, in the farms, maybe those who haven't been in the village for some time, but in the farms, what entitles a neighbor or a person sharing the boundary with a neighbor to go to the neighbor's farm and pick snails, for example. That is profit, and you can register that. And then power of attorney, I think is very well known. Contractual licenses, as the name implies, and then user rights and the certificate of allocation. This is also a new one. This pertains a lot in Kumasi. In most cases, when you are granted the land, especially by the stools or families, you don't really have a registered right. But you are told that, oh, go to the land and start developing whilst we prepare your documents for you. They have what they call a location note. Until recently, you could not rely on it to lay claim to the portion of the land. They're saying that pending the issuance of the land document, you can present this allocation note or allocation certificate to lands for it to be registered in the meantime, so that if anybody confronts you, at least you have something to show that you have maybe begun payment of what the lawyers call consideration or the value or the price. And so that is also quite innovative. Then qualification for title registration. Who can register any interest in land or right or title to land? Section 83 says the allodial owner. The allodial title is the highest paramount title from which all other interests flow or are carved out. That's the allodial title. So the owner of the allodial title, mostly stools, families, individuals may also be allodial title owners. Then anybody who holds a common law freehold, customary law freehold, and all the other interests that I mentioned earlier, all these persons, including companies, can also register these interests and rights in any land that they can lay claim to as being the owners. Now, the Act has also made some profound introductions. For example, where in dealing with the Lands Commission, for example, there is some disagreement or dispute, or even dispute between two claimants. This person says, the land belongs to me. The other one says, no, I acquired it first. Under the previous law, it appeared that apart from initial resolution processes that the Lands Commission or the title registrar may have engaged in, now it is specifically provided for alternative dispute resolution and the law, where then once the law provides for it, it appears you may have to resort to that before maybe your right to go to court may accrue. And that's a very important. Then also, the land registrar shall not register a large scale of land disposed to another person by the stool or skin or family land, unless the Regional Lands Commission in that area has given its consent. or his consent for it to be done. In the Constitution, it just said disposition of stool lands for valuable consideration. This act has gone ahead to add certain words. It could be problematic because the Constitution, the supreme law, the Constitution did not add family land. This one is adding family lands. There have been previous cases where the courts have clearly decided that stool lands are different and separate, independent of family lands, even if it is owned by the family that can lawfully nominate and install someone as a chief. So this can be problematic. But I on my own, in previous time, have even had problems with provisions such as this. And I think it needs to be looked at again. I do not see why, if a person owns land and he wants to dispose of it, it should be restricted by how many acres or plots. Some argue that because people are unduly dissipating the land, giving out lands to the detriment of the unborn. But my argument is, is it not better for you to sell and invest these monies in the education of the mothers who are now going to give birth to these new unborn people? Is it not better than saving just the land, with normally owners being indigent or men or people of straw, and then because of ill health, they may not even be able to give birth to the so-called unborn. And also the issue of stools, interest in stool land, or other forms of interest, that you cannot alienate it to a person who is not a citizen of Ghana for more than 50 years. It still doesn't look like it's prudent to me, with all due respect to the best brains that put the Constitution and this act together. Because, elsewhere, people are attracted to acquire land in the cities mainly because of how many years they can acquire. And so you are looking for value for money. It's not only about price, but how many years you can hold. Or if he's going to put up a hotel, for example, and you say he's only entitled to 50 years subject to renewal, it may not be so attractive to the person. No wonder they move to other places that we are well aware of, where it doesn't matter your nationality, you can acquire land for, say, freehold or 99 years in the least. Once you want to invest in projects that will benefit the state. Because if we look at the benefits that, for example, construction of a factory by a non-citizen will inure to us, employment, taxes, and so on, will be more than the reason assigned for it not being given out or for those many years. So I think the state can still look at it and perhaps change the rules and the laws to ensure that at the same time, the amount to be paid as consideration is regulated by the state. So the landowners will not be shortchanged, whilst at the same time giving the non-citizen, and which I see sometimes as discriminatory, because the Constitution itself is against discrimination on the basis of place of origin or color or race. But the same Constitution, in a way, also takes away the right of non-citizens as against that of citizens. This can be for another occasion, but that's my comment on that.
Okay.
Just to conclude on that, the land registrar can compel you to register your land if you fail to do so within the stipulated time. And then what interests a lot of people is about registration of land by spouses. Now the law is saying that if you are coming to register your land, you must indicate whether you are married or not. And if you are married and you fail to indicate, you are assumed or presumed to be holding the property for yourself and in trust for your spouse, male or female.
That's interesting. So, Lawyer Oppong,
yes.
Basically with your submission, when it comes to property rights, the new act actually has ensured that people's rights are upheld in a lot of instances. So it's good for business.
That's true, yes.
But your key problems are the limits of how much acreage my hometown chief can sell, or I can sell if I own the land, and the limits of the lease for foreigners. You think that it should be a level playing ground, just as Ghanaians do it, foreigners should also be able to do it. Those are the key issues for you. But let's look at the issue of registration and the processes. You've studied this space for a very long time. We did lap 1, lap 2 with the hope of sanitizing the space. Recently, the Lands Commission upgraded their infrastructure, that is their IT infrastructure. That was in 2020 or 2019. And right after, there was this huge backlog, people having issues with registering and even searches. How do we approach the process? And if you have to set a target for them, how long must it take me to register my land? How many days, how many hours?
Well, first of all, Lab 1, Lab 2, and the rest of them have been useful. In fact, is the byproduct of, or the product of this Land Act, substantially, as far as I know. Yes, I mean, registration has been quite problematic. It's also mainly because a lot of the lands are not registered in the first place. So if you want to acquire the land, you do not have absolute assurance that it even belongs to that person, except where you apply other forms of what you lawyers call requisition to ask adjoining landowners and so on. So if these lands were already registered, then you just go to lands, and with all due respect, there have been instances where if I go and depending on who my grantor is, a search can be given to you to confirm it. If subsequent person or another person also comes subsequently, a search, different search, will also be given to the person. But the truth is, in this act, members of officers of Lands Commission have also, as it were, been warned that they stand to even be imprisoned or suffer other forms of punishment if they engage in some of these fraudulent acts. So the main setback really, if I should say, repeat, is the lack of registration. There have been provisions about the setting up of the customary land secretariat. The problem is the owners of these lands, as I said earlier, are usually, they are wealthy but poor. The land they hold makes them wealthy, but they don't have money. So sometimes you get other persons who just go, acquire a large tract of land from them, and tell them we are going to register. The next time they realize some developers have been there and only that portion given to them is registered. So the opportunity to register these lands is a welcome one, except that these persons who own 50,000 acre land and so on don't have the money to be able to pay for the processes. So I think the states may want to look at it, where the state itself can approach a school or a family that we want to help you register this particular portion of land. We are prepared to give you exemption. We give exemptions to a lot of companies, frankly. Your pet subject, yeah. So why can't we do so for the families? And indeed, the benefit to the state will be greater than to the owners of the land. So that will really speed up the registration system. Now they have the barcode, which also makes it easier for you to at least do your own search on these matters. I will advise that perhaps we should go more digital and rather speed up the setting up of the secretariat, or perhaps enhance it for the electronic transaction. That will go a long way to reduce not only the role of middlemen and the expenditure, sometimes or a needless expenditure, but it also help to speed up the process and also reduce the amount of time that landowners spend just to have their properties registered. There is just one provision to which I think is quite innovative as well, that now in terms of priority, it's no more about the date of the instrument, but it is when the document was presented to lands. It may be problematic. But there has been instances and even cases at the level of Supreme Court where people, because of their influence in terms of maybe finance or their state in the society, were able to speed up to have their documents registered even when other people's own covering the same land had been deposited at lands. Now the provision is that it depends on when the document was presented to lands and not even when it was dated or when it was registered per se. Except that if I give you notice that I own this land and you are able to get your document to reach lands quicker than mine, that is fraud. The act exempts acts of fraud and mistake. If the Lands Commission mistakenly registers your land even though your document was brought later, that is a mistake, and the title document can even be set aside by them or the court.
I see. And that